Good afternoon and welcome to our education update for primary and secondary schools. I'm Catherine Kelly and I'm delighted to introduce our education team, which is Fiona Shield, Lorcan Mall and Anya Haberlin. We're going to go through a few different updates that we have in education law, and we hope that it will be of use to you all. The first issue I'm going to deal with is in relation to the disciplinary procedures. So you need to look at the different procedures because it's very, very important that you're on the correct one. If it's for primary, secondary, and community and comprehensive schools, it's 49/2018. And for ETBs, it's 48/2018. Very subtle differences between the procedures, but you need to make sure you're on the correct one because sometimes we have to guide clients away from a certain one and onto the correct stage in relation to competency, conduct, and in actual fact, the correct procedure. So please keep that in mind. The key principles in relation to the disciplinary procedures are they can commence at any stage. And this is very, very important. You may start at an informal or a stage 1 in relation to lateness, etc. But if it's something of a child protection nature or something very, very, very serious under the gross misconduct part, you might go in at a stage 4. So it's very, very important to assess what the level of misconduct is. So the person involved needs to get an opportunity to respond to the allegations raised, and they must be given everything in advance of a meeting. So give them all the documentations, the actual substance of the allegations, and allow them to respond. Key here is a right to examine and challenge all evidence. If you're at a stage 4, we would always say that the witnesses would need to be made available to the teacher. So, for example, if in a classroom an SNA made an allegation against a teacher, which was very, very serious, that SNA would have to make themselves available for the stage 4 hearing. In relation to representation, we would say that a lawyer can be involved in a stage 4 procedure, even though the circular doesn't provide for it. But this is a case where somebody's about to lose their livelihood, and therefore we would say maybe just consent to it to be reasonable. And also any sanction will be proportionate. There's no point giving a final written warning in relation to somebody who's turning up late every now and then. So just look at the various sanctions and assess accordingly. In relation to stage 4, it's very important that you have a comprehensive report, which goes to the board or the chief executive, depending on the procedure. No findings of fact. So what we always say to people is, please don't say they were dishonest, they lied, etc. It's all about your concerns in relation that this may have happened. So it's an allegation all the way along. So advise them of the nature of the complaint and tell them that they can have their trade union representative there. Also, they need to know that if it's gross misconduct, the normal consequence will be dismissal, although that's not the only choice. It could be demotion, final written warning, etc. So be very clear in relation to what the allegation is and the sanction that may flow from that. So what do they do if it goes to a stage 4 and there's a dismissal? There's a disciplinary appeal panel, and that's an appeal under the grounds set out in the circular. So the board is not obliged to accept the decision of the DAP, and this is really, really important. But you should look at the grounds of appeal in the circular because it's very, very limited. It's not a full rehearing of the stage 4. And that's very important because I think sometimes people have a misapprehension in relation to this. We have attended quite a number of disciplinary appeal panel hearings, and we've been successful in having the dismissals upheld. And my colleague, Lorcan Mall, might come in here because he has dealt with one very recently.
Thanks, Trina. So I guess our advice is, and a kind of a top tip here in relation to dealing with disciplinary issues in school, is to tackle problems early. Don't allow things to fester and build up. In a particular case that we dealt with, there was a significant issue in relation to a teacher and how they conducted themselves with students. And I guess a learning from that was that went over a period of number of years, and there was quite a big issue to deal with at stage 2. But we went through the process step by step in terms of going through each stage. And unsurprisingly, in this case, the conduct continued despite being issued with a written warning, a final written warning. And so going through the process in that linear fashion was very helpful in terms of a disciplinary appeal panel, because they could see that the teacher had been warned, had been disciplined, and yet the behavior still continued. And so that was a good outcome for the school, because they could show that the behavior and the conduct was continuing despite putting in measures to help the teacher improve and providing professional advice in relation to her conduct in the school.
Thanks a million. That's really helpful. In relation to other remedies that they have, then they can go to the Workplace Relations Commission, unfair dismissal or employment equality claim. Then it's an appeal to the Labour Court, which is a full rehearing, and then onto the High Court on a point of law only. And it's very, very important here. It's not a full rehearing, because we've had a number of these cases which have come before the High Court. In particular, this is a new one, which was last year. It followed an investigation by the school and the inspector in the department in relation. One of the allegations was inflated school enrollment figures. So they went down through the stage 4 process, and following that, the principal was dismissed. This was appealed to the DAP. The DAP agreed with the Board of Management and upheld the dismissal. The principal then went to the Workplace Relations Commission, and the Workplace Relations Commission found that the dismissal was unfair, and ordered his re-engagement. So, very, very significantly here, it didn't award compensation, which would be the usual remedy for an unfair dismissal claim. They said that he should be re-engaged. So following advice, the Board of Management decided to appeal it to the Labour Court, and they also found in favour of the principal. The Board of Management then went ahead to the High Court, but this is only on a point of law, so it's not a full rehearing. The High Court dismissed the appeal of the board, but ordered the principal's re-engagement from the date of dismissal, and also quite onerously ordered the payment of all arrears of salary to be paid immediately to the principal. Following further advice, the Board of Management appealed to the Supreme Court, and the Supreme Court thankfully held that the High Court had exceeded the proper scope of an appeal, which is on a point of law only. In essence, they were saying, they shouldn't have been dealing with the facts of the case. The decision of the High Court should be set aside. They said that the decision to re-engage was wrong in law, because you should only use that if there's no breakdown of trust, and in this case, there was a breakdown of trust. Also, a new principal had already been appointed. So in this case, they decided, and it's very good for general employment law to say that re-engagement and reinstatement should only be used in very limited terms, and it didn't apply in this case. So it's a very interesting case. I'm going to hand over now to my colleague, Anya Haberlin, who's going to talk to you about an interesting update in relation to ancillary staff and retirement ages. Thanks, Anya.
Thanks, Catherine, and good afternoon, everyone. So I will be speaking today about ancillary staff and retirement ages, and the clauses that may be contained in contracts of employment of ancillary staff. So when we speak about ancillary staff, we're speaking about secretaries, cleaners and caretakers employed in schools, where the employment relationship is between the Board of Management and the ancillary staff. A really important point to note at the outset is there's no such thing as mandatory retirement ages anymore. Under Employment Equality Acts, a mandatory retirement age must be objectively justified. So that's a really, really big important point. So we can't just look at a contract of employment and say, for example, in that contract of employment, it states that this employee shall retire at 65. It's not the case that we then go up to that employee on their 65th birthday and say, this is now, your employment is terminated. So that's absolutely not the case. It's, I suppose it's different in the case of teachers where that may happen, and there's a kind of awareness, that they're working till the August of their, last 65th birthday, for example. So just to note, a retirement age may be in a contract, but that is not absolutely determinative of their retirement age. So if we move on then to the next slide, we'll see that in order to enforce a mandatory retirement age, there has to be three things. So the age at which an employee must retire must be clearly stated and applied consistently. The employer must have a valid reason for having this policy, and it must be objectively and reasonably justified by a legitimate aim. So again, that's very vague, that second bullet point, but we'll speak about that a little bit more in the next slide. And the third thing is the means of achieving the aim are proportionate and necessary. So again, we know that there's not this blanket rule of a mandatory retirement age, but it needs to be a more considered approach, bearing in mind this 3-step test and kind of having a very kind of, it's a lot more nuanced than just terminating employment at the ages of 65 or 70, for example. A really helpful Supreme Court decision that was handed down last year in relation to a revenue sheriff who was employed as a solicitor, who brought a Supreme Court appeal, and this was the case of Mallon and Minister for Justice. It's really helpful, I suppose, when we look at the area of retirement ages, because a lot of our law had come from Europe. So now, for the first time, we have a Supreme Court decision which really teases out the legitimate aims we saw in the previous slide. Because as you know, it's quite vague and it's kind of difficult to look at the business needs. Say, for example, what does the school want in relation to its workforce? So we have these 6 bullet points in relation to the legitimate aims. So they are employment of younger people, promotion of young people to professions, establishment of age structures, the sharing of employment between generations, avoiding fitness to work disputes, and succession planning. So as you'll note there, a lot of those legitimate aims are absolutely interrelated. And I suppose a big theme that's coming out from all of those is the kind of maintaining an age diversity within the workforce. So there has to be a very consistent policy that's consistently applied across, the school in relation to retirement ages, if that is what the board decides to do. So if we move on then, I suppose the main points to consider then, if it is the case that, you see a contract of employment, say for your caretaker, for example, and it has the age of 65 on it, what do you do as an employer next? So there's some really important points to consider here. And that's whether the role is department funded, school grant funded, or whether they're paid through another source.
And I think that we actually had a recent case on that, didn't we, Anya?
Yes, yeah, we did. And it very much mirrored, the caretaker situation. So it was a school, a caretaker was employed by the school, had reached their retirement age, and then we as a school had to conduct a very in-depth analysis on exactly how this caretaker was funded, because ultimately the question that had to be answered was whether this caretaker could be deemed a public servant or not. So as part of that exercise then, we had to look at whether the pay of the caretaker was sourced through, for example, capitation grants or ancillary staff grants. And then we had to look at whether their salary yearly was subject to public service agreements, whether they got pay increments in line with other public servants, and matters like that. So all of those factors, allowed us to argue the point that this caretaker could actually be deemed a public servant. But for example, if they were paid through another source, for example, we know that schools may run astroturfs and, have a source of revenue through that. If their salary is paid exclusively through that, it's very unlikely that you'd be able to argue that a caretaker then was a public servant. So that's just another point to note. So if they are deemed a public service sector worker and joined before April 2004, the compulsory retirement age is 70, subject to suitability and good health. And if they joined between the 1st of April 2004 and the 31st of December 2012, there's no specific compulsory retirement age for that group of people. So if we move on then, the key takeaways, I suppose, because it is quite a complex area of law, but thankfully now we have that Supreme Court decision from last year, which really kind of, I suppose, clarifies the legitimate aims point. But I suppose the main point to take away from today would be just exercise absolute caution when terminating employments on the grounds of retirement for ancillary staff. If you are granting fixed term contracts to that person in order to extend their contract of employment beyond the retirement age in their contract, know that this has to be done obviously contingent on their capacity in undertaking the role. For example, if it is a caretaker, if it's a physically demanding role and they are going up on ladders, on a weekly basis, or cutting hedges, or something that would require some sort of physical requirement, then you'd have to see if that person was physically capable of doing the job. And that's where we'd stress the importance of seeking input from Medmark, because we're not medically, well, most of us are not medically qualified to make determinations in regard to whether someone is or is not able to do a job, you know, to the best of their ability from a medical standpoint. So if there is any question mark on that, I would absolutely be seeking input from Medmark. But one caveat to that in kind of handling, I suppose, any issues around ancillary staff and retirement ages is that, I suppose, always look at it through the lens of this could possibly be an age discrimination claim, because age is one of the protected grounds under the employment equality legislation. So, you know, if it is the case that, you know, you're terminating a contract on the grounds of retirement, and, you know, that, you know, Medmark have properly been consulted, and if they're absolutely not capable of doing their jobs, as long as you have that kind of paperwork in place and it can be absolutely certified, there's no kind of possibility of age discrimination there, and you're relying on very objective factors, then it should be absolutely fine. But it is a very fluid area. You kind of have to deal with it on a case by case basis, but just the main takeaway is it's not an automatic kind of retirement for ancillary staff. So it's kind of very different to teachers in that regard.
Thanks, Anya. And I think the main thing to remember as well is that normally we don't end up in the High Court in relation to these claims. It would normally be an age discrimination claim to the Workplace Relations Commission. And, you know, there would be no exposure to costs for that person. So the case that we had was taken in the High Court, which would be very unusual, because then there's a huge cost implication for somebody if they don't win their case. But thankfully, you know, that matter settled before we got anywhere near the High Court steps. So that was a great result for us. And now I'm going to hand over to my colleague, Fiona Shiel. We recently did an update to schools in relation to data protection and a new data protection toolkit, which came from the Data Protection Commissioner. And so she's going to run through some of the key pieces of that update.
Thanks, Catherine, and good afternoon, everyone. So yeah, there was a toolkit which was published by the DPC just before Christmas, and it's well worth a read. It provides really good guidance for schools in relation to managing students' data and handling access requests and ensuring compliance with data protection legislation. So before its publication, the DPC consulted with a number of management bodies in the education sector just to get a picture really of what areas schools needed guidance on. And following on from the consultation process, the toolkit was published. It's about 70 pages long. There's lots of examples throughout. It's a really practical, useful guide. And yeah, we recommend you have a read if you haven't had sight of it. Like, we as a team deal with data protection queries on an almost daily basis. Like this morning, I had 2 phone calls with principals, one in relation to a data breach and one in relation to a data access request. And it's an area that's not going away. It's getting busier and busier. So it's a good document to be aware of. And it's important to note that the document is in relation to student data and how to handle that, rather than handling your staff data or parents, requests made from parents. And what's really clear throughout the document is the principle that the best interests of the child are going to be taken into account and they're paramount. This is highlighted throughout the document. So again, just to bear that in mind. There's a couple of helpful clarifications within the document. The first being that the age of consent is clarified. So it confirms that once a child has turned 17, their data protection rights should not be exercised by their parent. So schools should deal directly with the student. That is to say, if a student at the age of 17 requests their data, that they're entitled to do so, and you deal with the student versus the parent. And we've never had that guidance before, so it's helpful. But just to caveat what I've said there's provision in the Education Act, which basically states that a school has to ensure that a parent has access to records kept by a school which relate to the student's education. So there's a slight conflict between the DPC guidance and what's contained in the Education Act. So that is something be aware of, and something that we've had to deal with as a team previously. I have on the slide there data protection impact assessment. So there's a big piece around this within the toolkit, and the DPC advises that schools should carry out these assessments, which identify risks associated with processing children's data. So there's in-depth guidance in relation to that piece. So it's just something to be aware of. There's a lot of guidance in relation to how schools should deal with third parties. And I think the main thing here is that there has to be a basis for sharing data, for sharing student data with an outside agency. So just by way of example, schools have a mandatory obligation to share data with TUSLA in relation to a child's attendance. That's a statutory obligation. So there is that basis there. But again, the document stresses the importance of, having that basis for sharing data with outside organizations. There's also guidance around CCTV. So it's important to remember that CCTV footage qualifies as data, and schools should have a clear policy in place regarding CCTV. And the toolkit advises that there should be appropriate signage in place informing staff and indeed students that CCTV is in operation. So just to bear that in mind. Yeah, so the key takeaways, I think the most important one from our perspective anyway, is that there's clarification around timelines for dealing with data access requests or dealing with a data breach. And it basically says that regardless if a school is closed for July and August, the clock doesn't stop. So if you get a data access request in from a student or a parent in relation to their child's data and records, you have to respond to it. So there's a month timeline which you respond. Now, we appreciate that may not be possible, and our advice there is just to engage with the person who is requesting their data. And if you need more time, look for more time. The DPC like to see that a school is engaged rather than just left it. So I have on the slide there that email and post should be monitored during midterm, during Easter holidays, and during July and August. And similarly, if there is a data breach related to the school, the timeline is 72 hours to report it. And again, the clock doesn't stop just because the school is closed or just because it's a weekend. So appreciate you might not want to hear that, but that's what the guidance has clarified. So just to be mindful of that. So we're expecting further guidance to be published. They've asked for the education bodies to give feedback on the published document, so it may be updated. So again, if that's the case, we'll be sure to put out another education update.
Thanks very much, Fiona. And I think, it's really important to focus on monitoring the post, because we have had, a few occasions where things have come up and, nobody has been monitoring. And then, there's a complaint made because, the time limit has gone on it. So it is really important. And just to acknowledge receipt of it, and then you can get an extension of time to allow the school to get the documentation together. There's no problem with that, but you just need to make sure that you're dealing with it. And then also the breach. I mean, it may be something really, really minor, but I would always be very cautious and report it, to the Data Protection Commissioner, just to be safe. And the majority of time, it doesn't lead to anything at all. So if in doubt, report it and get advice from them. And just don't leave it, because otherwise it will come back on you. So I think that's really, really important. Before I move on to the next speaker, I just wanted to say that you can put your questions into the Q&A feature. If you have any questions that we might look at the end of the webinar, so feel free to put them in there. And now I will pass you on to Lorcan Maul, who is going to deal with an overview of Section 67 of the Education Act. And he's also going to run you through a really, really important decision in relation to school expulsions that also went all the way up to the Supreme Court last year and was a really, really good decision for schools. So thank you, Lorcan.
Thanks, Trina. So firstly, as Trina has mentioned, I'm going to be looking at Section 67 and the legal framework governing school placements for children with additional needs, which is provided for under Section 67, which was amended in 2018, and that was due to the lack of placements for these children in schools around the country. And we are now seeing an increase of the government and the state bodies using their powers under the Education Act to direct schools to take children, or under Section 37A to open special classes. So what Section 67 does is it grants the NCSE, the National Council for Special Education, the power to designate a school for a child with additional needs if the parents have made all reasonable efforts but have been unable to secure a placement. And when making that designation, the NCSE is required to consider several factors. Primarily, the focus is on the child, including their needs, the parental wishes, and where appropriate, the wishes of the child themselves. It's also appropriate for the NCSE to consider the locality of where that child is being sent to school. So, for example, last year, the NCSE made a direction on a school to take a child where that child had been going to another school, but they were traveling hundreds of kilometers per week. And that was seen to be not fair on that particular child, and it was having an impact on them. So that's something that the NCSE can also consider. And then another thing that has to be considered by the NCSE is the actual school's ability to accommodate a child with their resources, and that's a critical factor. So I guess the key takeaway from this particular section is that the law does place a clear obligation on schools to admit directed children while ensuring that the NCSE's decision-making process is informed by the best interests of the child and the realities of the school's capacity as well. So moving on now to the next slide, we're going to look at how this process actually works in practice. And the process begins when the NCSE issues a designation notice to the school's Board of Management. And this notice informs the school that it is being proposed as the designated placement for a particular child, and they will give the name of that child. Schools are normally aware that this might be coming down the road, because before they make this designation notice, the NCSE will reach out and see if the school can take a child, and there'll be back and forth between the board and the NCSE. However, if they do make that designation notice, it's important to note that the school has 10 days to put their concerns or objections in writing to the NCSE, which the NCSE must then consider. And again, it's really important to highlight at this point that it is 10 days. And this can happen during the summer, it can happen during other kind of holiday periods. So as Fiona had mentioned, it's really important someone's checking the emails, checking the posts to ensure that you're not missing this, because if you miss the 10-day window, the NCSE will carry on and proceed with the direction. So after receiving the representations from the board, the NCSE must consider them before deciding whether to issue a formal direction to admit that child. And if the NCSE proceeds, the school must comply with that direction. So the designation is the initial proposal, and the direction is the final legal binding order made by the NCSE. And really, this two-step process provides school with only a limited opportunity to raise concerns before an admission decision is enforced. So moving on to the third slide then, what we need to look at is the key considerations that the NCSE must take into account when deciding to make a direction. And unfortunately, there's no case law on this area yet. It's a new area. There's been no challenges. So we don't have a lot to go on as to how the courts will interpret these kind of directions. But we will have to go back to our basic principles of with any administrative decision, the state and the NCSE must ensure that their actions are legally sound, reasonable, and procedurally fair. And these are the judicial review reasons that any state body must consider when they're making a decision. So firstly, looking at procedural fairness, schools must be given the full 10-day period to make representations, and that can't be shortened or reduced. Those representations must be meaningfully considered. So, for example, if a school is making very serious concerns in relation to the fact that the school is oversubscribed, that they don't have the particular resources in the school building isn't fit for purpose for a child with additional needs, whatever it might be. I've heard of schools getting architects in to do reports, or educational psychologists to back up their position. So these are things that the NCSE have to consider. Secondly, any decision by the NCSE must be reasonable and must be proportional. So that, again, taking into account the school's capacity and resources. And then thirdly, the NCSE must act within their legal authority under the Education Act. And if a school can demonstrate that it is genuinely unable to accommodate the child, and the NCSE has failed to properly assess this or provide resources, this decision could be subject to challenge. So in conclusion here, Section 67, places a clear obligation on schools to admit children with additional needs when directed by the NCSE, but that process must be considered and conducted fairly and lawfully. So then moving away from Section 67s and on to expulsions, we were successful in a case that we took to the Supreme Court from a decision from the High Court early last year. And this was a case involving a serious bullying issue that was occurring in the school, and it was happening online and it was happening in person. So it covered a lot of the bullying kind of topics that would normally schools would normally see. And in this case, the principal made a recommendation to the board of management for expulsion, and the board agreed with the principal and made an opinion to expel the child. This particular child had a solicitor involved, and the solicitor wrote to the school saying, could the students remain in the school pending a Section 29 appeal so that they could carry out their junior cert studies and would bring them up to the junior cert year. And there is no legal basis to do this. Once a child has been expelled or a student has been expelled from the school, they are no longer an enrolled student in the school. So therefore, the school on that basis said, no, that's not provided for under the Education Act, and the child would not be able to stay. The solicitor then went into the High Court and sought relief on that respect, and the High Court granted the relief and put the child back into the school pending a Section 29 appeal. We thought that was incorrect, and also it wasn't fair on the other students who were being bullied in the school, and further bullying arose while the student returned to the school. So we appealed that decision of the High Court to the Supreme Court. And in that decision, the Supreme Court agreed with the school's position that the High Court had fell into error in relation to allowing the student to remain in the school pending a Section 29 appeal. And Justice Hogan in that judgment stated that there was no provision for any interim relief under the Education Act while a Section 29 appeal was being processed and being heard. So he agreed with the school's position. There was also another decision or a judgment by Justice Collins in that respect, and he reaffirmed that appropriate weight and interest has to be given to both the staff and the students of the school who are being affected by the behaviour of the student. And so that again reaffirming the health and safety obligations on the school, that it's a balancing right exercise between one student versus another. And so this was heavily relied on, and this is something that we're kind of giving advice on all the time, that when schools are making a decision to expel, they must balance everyone's rights, and one person's rights doesn't outweigh the other people's rights in the school. Then finally, what Justice Collins said was that by putting that student back into the school, it was a significant imposition on the school because, one, the student had been dealt with at the highest level of sanction. It wouldn't have looked good for the school management to have that student back, and that would have affected their credibility and how they managed that particular student. And there was also issues in regards to how that student would be engaged with if they had been expelled and weren't technically a student under the Education Act. So this was a really good decision for schools. And it really reaffirms the principles that we had been stating when we've been advising on schools in regards to expulsions and, the health and safety obligation and what the schools have to take into account. And it's a good lengthy decision from the Supreme Court, because previously the decisions from the Supreme Court in relation to expulsions were quite short, but this is quite a good one. So just remember top tips in relation to expulsions. You need to get your advice from your management bodies or get your legal advice. I know some schools go to state bodies or education welfare officers. They're not too familiar with the rules of how an expulsion process works. So really go to your management bodies first. And then if you require legal advice, you should seek that.
Thanks, Lorcan. And I think it really is so useful for us because we're seeing more and more proposed expulsions, suspensions, etc., on grounds of health and safety, bullying, etc. And, in the past, we have had a lot of solicitors for students and their parents threatening the High Court and going into the High Court before the Section 29 appeal process had been concluded. And this gives us great guidance in relation to it, and it should stop parents from going that route until the Section 29 appeal has happened. Now, I'm actually going to go on to questions and answers. So I'm going to have a look at some of the questions. They're rolling in here, so I'm going to ask some of the team to deal with them. There's one in particular here. What if, I think this is for Anya, what if an ancillary staff member has no contract? And obviously that happens a lot because sometimes the contracts wouldn't be there, or they would have been mislaid or something. So could you answer that, please?
Yeah, absolutely. And exactly as you said, Trina, it could be like legacy issues, and you know, you're a newly appointed principal and you realize that all your ancillary staff may or may not have contracts. So the big point here is to, our advice always is to get contracts in place. Under legislation, under the Terms of Employment Information Act, core terms should be given to employees within 5 days of starting a job, and then the remaining terms should be given to them in writing within 1 month. So that's the legislation around it. Now, in reality, that doesn't happen, and we're very aware of that doesn't happen. So what we'd always be saying is to try and kind of, you know, remedy the problem. If you are giving the contract of employment to them, 2 things to be aware of. Make sure that a member of the board of management, chairperson usually, signs the contract. That's really important. And secondly, if it is a contract that's been given a few years, say, after their commencement date, please ensure that the terms in the contract mirror their terms that they have been enjoying to date. So you're not kind of, you know, changing their terms of contract, because that would be not permitted under legislation.
Okay, great. Thank you very much. And there's another one in here that Fiona might deal with. It's and I can also comment on it. Can a student over 17 request the school not to share their mock exam results with their parents?
Again, like I said earlier, this is a kind of tricky one because the DPC guidance is in conflict with actually what the Education Act says, and this crops up every year around exam results. So you need to kind of look at it on a case-by-case basis, because further to the DPC guidance, you deal with the student and they are entitled to that data. But under the Education Act, a parent is entitled to the educational records of that student. So Catherine, you know, it's kind of a damned if you do, damned if you don't type of scenario, isn't it really?
Yeah, I mean, we have had a few cases on this, and you know, I think every time that you get something like this, and you have to look at the particular circumstances of that student. And, you know, if there's parental alienation going on, if you are concerned that, you know, giving the results will cause any kind of child protection issue for this child, then you might have to have a rethink on it. And, you know, we have had decisions from the Data Protection Commissioner which have supported schools when they've said, we were concerned, we have a child protection concern in relation to this, and we're not sharing those results with that parent. So the majority of the time, it's only in a case where you have major concerns in relation to sharing it. And you know, we had another case where he said he was discriminated against as a separated father because the school had refused to give results to him. And we fought that all the way, and we were thankfully successful with it, because they agreed there was no discrimination there. The school was acting in the best interests of the student. And that's of paramount importance in anything. You always have to look is what is in the best interest of the student involved. And it wasn't in her best interest to share those results with her father. So I think that's really the most important thing. I think there's one here, I think it probably refers to what Lorcan was presenting on. Is it 10 working days or calendar days? That's
I think it's 10 working days.
okay.
It's not school days. It's 10. It says 10 days in the act, because I actually looked that up.
Yeah.
But you know, I think what happens is I think the letters that I've seen, the NCSE have put a date in terms of a response to get back by, so they will specify that.
Okay, well, that would be very, very helpful, because there's a huge difference between 10 working days and 10 school days sometimes, you know. So yeah, we need to get clarification on that. There's another one here, is where's the best source of a contract for a cleaner? It all very much depends on your management body. They would normally be able to provide you with contracts. I know CPSMA, JMB, etc. They would all have template contracts that they could provide you with in relation to a contract for a cleaner. or a contract for a caretaker, etc. So I would say that you should contact them. Now, there's one here which we get a lot, and I don't know who wants to put up their hand on this one, because it's, what should you do if a parent records a meeting? No takers.
No.
I think it's obviously it's processing someone's data. So if you're not giving permission to record a meeting, and they're recording you, they're in breach of their GDPR obligation. So I think you can quite frankly say, no, I don't consent to any recording.
Yeah,
don't consent to any recording of a meeting. And ask them to put their phone away, because normally they put their phone on the desk or whatever it might be. So it's quite obvious if they're recording. But you might just say, look, for this meeting, maybe take your phone off. If we could all put our phones away into our bags or something like that, so we can really focus on the subject of the meeting. That might be the appropriate way to deal with that.
Yeah, I think it shows that there is a breakdown in trust between the parent and the school as well. So, you might have to have a word with them in relation to it. And, there is a parental complaints procedure there. If they're not happy with the school, that's basically what they need to use, and not to be recording staff, because that is a growing problem with people being recorded, not only staff, but also students as well. But that needs to be dealt with in one of your policies. And there's also one in here in relation to Garda requests. And I presume that's a Garda, which we do advise on sometimes. Gardaí arrive at a school and look for the documentation in relation to a pupil. And our advice is always that we need to see in writing the basis upon which they are seeking that information, because sometimes what happens is they just call to the school, and the school feels obliged then to give the information. For GDPR purposes, we need to know the purposes of that in order to cover ourselves. So I think
Trina, we had that only last week, where the school got a letter in from the guards and just assumed, oh, I need to hand everything over. But actually, the section of the Data Protection Act that the guards often rely on in the letter is actually not mandatory. So you need to be really careful. You're not breaching someone else's rights by giving that data across. So often it's not a clear case of you give it and that's it, because there's other considerations. So that section of the legislation is not mandatory. So we would advise to get advice on that, just so you don't end up with a complaint against you.
Yes, yeah, absolutely. And everything also has to be redacted very carefully, because even though you may be asked for details, I mean, I know roll books sometimes get asked for. You have to be very, very careful that you've taken out everybody else's names, otherwise that's a breach. So, you do have to be very careful about it. And I know a lot of schools are very good at that, in fairness.
Yeah.
There's another one in here. What are the legal obligations of a school towards a Leaving Cert student who's not attending school because, in the opinion of the parent, the school has not created an environment where their child feels autistically safe? Are we obliged to differentiate work on Microsoft Teams to that student so that the student can access the work? What are the school's responsibilities around this? I mean, Lorcan, what do you think about that?
Like I've dealt with a few of these before. I mean, no obligation in relation to the school to differentiate work on Microsoft Teams so that the student can access the work. I mean, it would be very hard for teachers to differentiate work where they don't have the student in front of them and they're not attending school. I don't know how a school could differentiate work in that respect. Also, the student who is in Leaving Cert or is working towards Leaving Cert is going to be over the age of 16. So it's a matter for them if they want to attend school or not. There's, the education welfare officer doesn't deal with students over the age of 16 if they're not attending school, because there's no legal obligation for them to do so. But I think that the position of the school would be, well, we're providing services in a school environment. Your child is entitled to come in and receive them. But if they decide to work from home, that's on them, and they can avail of homeschooling from the department, get a grant for that or something like that. But I see this in primary schools more often than secondary schools. But my thoughts on that would be, there's no legal basis for
no. I mean, we have an obligation under the Act to reasonably accommodate students, but that wouldn't go as far as that, in fairness. There's one here that we have to deal with a lot of the time because we've actually had complaints made in relation to what if a school makes a child protection referral to TUSLA, and then there's a request made by that parent in relation to looking for that information. And I mean, I don't know what anybody else thinks, but my advice would always be is that you have to seek the advice of TUSLA. because there may be a child protection issue in releasing that information, and that child may be put in danger as a result. I mean, Fiona, what would you think in relation to that?
Yeah, I would agree. I would push it back on TUSLA as much as
Yeah.
possible.
Yeah.
We've
However
had
helpful or unhelpful that you know they may be in that regard. But
And you
yeah,
may not get it in writing, but at least you
no,
can keep a note of it on your file that
yeah,
you spoke to TUSLA and this is what they advised, you know. So I think that's very important to put the call in anyway.
yeah, and to
You know,
have that
somebody-
paper trail. Yeah.
Yeah. Anya, you were going to come in there.
Yeah, we've had a lot of those actually on the team recently as well. Like, and it's always kind of surrounds the situation where a disclosure is made to an SNA or a teacher,
Yes.
a child a referral has gone into TUSLA, and then the parent in kind of retaliation nearly asked for the you know, possibly asked for the request. So first thing we'd always say is go to TUSLA, but then echoing exactly what Fiona said in her piece about the toolkit, the children's interests are at the forefront. The DPC are now extremely exercised about, you know, the children first mentality, and that there's no automatic right for any parent, subject to the Education Act and getting the educational progress, but there's no automatic entitlement for a parent to get their children's data because they are their own data subject. So like absolutely get advice from TUSLA, but be very slow to release something to a third party that ultimately, you know, doesn't relate to them, or if it could have possible adverse effects on the data subject, then that needs to be considered as well.
Yeah.
Okay. I mean, somebody has said here that they had that with TUSLA and they said it was a school decision. I mean, if you get that, then you can say, well, it's a school decision and we don't feel comfortable releasing this, and stand over that if you get a complaint to the Data Protection Commissioner and deal with it then. And that's what I would say if you don't get a definitive answer from TUSLA. That would be our advice. There's another one in here in relation to if a member of ancillary staff never had a contract and has worked at the school for many years, can a contract be given? Would it be a fixed term contract? By issuing a contract, would it be seen as age discrimination? Anya, what do you think about that?
No, so if they're in the school, for example, for 5 years, it's, you know, it's very clear that it's a permanent, well, obviously subject you have to look at, you know, are they covering, for example, a sick leave or a maternity leave? But if there isn't that specific term in the contract, it's most likely going to be a permanent contract. So just be very careful, like you're putting in the date of commencement as exactly the day they commenced, whatever amount of years ago, and it can't be seen as age discrimination because we're actually complying with the legislation. So by giving them a contract, we're, you know, actually just complying with their statutory obligations under the Terms of Employment Information Act. But just one caveat to that: make sure that, I suppose, the duties and those elements of the contract, their annual leave entitlement, their salary, mirrors exactly what is happening on the ground.
Exactly. I agree with that completely. Now, there's another one as well. I mean, we could be here all day. There's so many really good questions, actually, and stuff we come up against all the time. If parents are refusing to cooperate with the school, i.e. through the involvement of NEPs and external agencies in the school, is the school within their rights to suspend the child, if required, and state in the suspension letter that the child can only return to school when the parents consent to NEPs? We actually have had this as well. And we have suspended children on the grounds of health and safety because the school would get to, you know, they would have tried absolutely everything. And there's no cooperation from the parents to try and get external agencies involved. So we actually have done that in the past. And it has worked to try and get some kind of engagement from the parents. I mean, Lorcan.
Yeah, but I think that the school
involved
needs to
on
be very
that.
careful about how they word that. I mean,
Yeah.
they're suspending on the grounds of health and safety. They're not suspending because
No.
the parents are refusing to cooperate with NEPs or to allow the school to contact NEPs. And I think what would have to follow is a letter from the school saying, well, we tried X, Y, and Z with this particular child. We need the expert support from NEPs. And then you could say we have serious concerns in relation to, you know, for example, that if NEPs are not going to be involved, that the placement it would appear to be breaking down. So they're forewarned as to what might occur if there's no engagement from the parents.
Yeah, absolutely. There's another one here which is quite simple to answer, actually, and this comes up to what contract applies if an ancillary staff member refuses to sign a contract. Many times we've had this issue happen, and we would always say you give them the contract. They don't have to sign it. You know, that's what they're working under. Those are the terms and conditions. You keep it, you know, in your filing cabinet or wherever you have it. And that's their contract.
And the legislation says that the only person who has to sign the contract is the employer.
Is the employer.
Yeah. So, and just to make sure that you have a signed copy by the employer on file and that you've showed that you've tried to give it to them.
Yeah.
Yeah, we had that in the WRC recently where there was various claims. One of them was that she was never given a contract. She just didn't like it, didn't want to sign it. And the WRC adjudication officer came down in the side of the school and said, look, what more could you have done? You gave her the contract. So she was not successful in her claim in respect of not having a contract. So, yeah.
I think what we always say on our team is like when we end up in front of the WRC, we always want to look at like the reasonable employer, you know, so it's much easier if you have tried reasonably to do this and yet there's been a refusal on the part of the employee, you know, so I think that's really, really important. And somebody's asking if we're organizing a summer course on legal issues for principals, and they say it would be greatly appreciated. Well, we'll have to have a think about that. So there's also what do you do if parents do not want a child to participate in SPHE program? There are huge concerns about this child and TUSLA involved. That's another issue that we've had come up, and you know, you have to work very, very closely with TUSLA in relation to it. Again, what's in the best interests of the child? Sometimes parents feel as if they get to call the shots in relation to students, but it's very much centered on the child. So I think you would have to use that as a means of trying to make a decision on that. And there's one last one. If the last contract on file for a caretaker is the job share one, can the caretaker refuse to sign an updated contract where the only changes are doubling of days to work over the summer? Oh, and yeah, that's a tricky one.
Yeah, so I suppose two things to be kind of aware of there, like, are we changing their terms and conditions? If we are, we have to give a new contract to that employee, and we have to keep the written terms on file. And exactly as we said, you know, that it's signed by a member of the board of management as the employer. But just to be conscious, if the job share is you know, depending on the service, just be careful on whether it's, if it would be deemed a fixed term contract, they could possibly be entitled to a CID. That's just something you'd have to be aware of.
But a contract of an indefinite duration. Yeah.
So that is very important. But ultimately, if they do not wish to sign the contract on the new terms, then their job share contract is finished. It's done. So that's, they're entitled to look at the contract and decide if they want to, sign up to those terms and conditions. And if they don't, that's fine. The job share is terminated. And as long as we don't have any continuing obligations under the fixed term legislation, then it's fine.
Okay, well, I think we're going to wrap it up there. And I just wanted to thank everybody for attending today.